Hi, I'm Nikita Veremeev, and no, I'm not here to tell you how to change your life in 21 days or make a wish under the new moon. Instead, I have something more grounded and vital: how to successfully run your business while adhering to all legal and financial requirements. Today's focus: the non-disclosure agreement, or NDA, and how it protects your ideas, strategies, and trade secrets. If you take your business seriously, this is for you. And even if you are not, still you may watch this video and have something new for yourself. A non-disclosure agreement is much more than a piece of paper. It is a legal contract in which one party provides confidential information about their business, products, or know-how to another party, and the other party commits not to disclose this information to anyone else and to keep it confidential for a specific period of time. NDA protects confidential information and intellectual property by detailing what information must remain confidential and what information can be shared or disclosed to the public. In 2017, Waymo, Google's self-driving car division, filed a lawsuit against Uber, claiming a former Waymo employee had downloaded 14,000 confidential documents before joining Uber. Despite an existing NDA, the case demonstrated how crucial the NDAs are in protecting trade secrets. The lawsuit was settled for $245 million. A non-disclosure agreement is typically signed at the outset of business relationships. However, it can also be executed after entering into such relationships if additional protection of confidential data is needed. Companies use an NDA in various situations. For instance, when an organization enters into a partnership agreement committing to perform tasks for a partner without compensation, the partner may become privy to the entity's approach to service delivery, trade secrets, patented process, marketing strategies, or any other valuable business information. Another fine example where an NDA is necessary is during the sale of a company. An enterprise looking to sell itself may require any potential buyer to sign an NDA to protect confidential information that the company may disclose during the sale negotiations. Similarly, an organization may enter into an NDA with potential investors or sellers, suppliers. In 2010, Dorchester Project Management Ltd. entered into an NDA with BNP Paribas regarding a property development deal. BNP breached the NDA by failing to secure a similar agreement from third parties, leading to a rival bid and a legal dispute. Indeed, don't just protect your information, they create a foundation for trust, security, and collaboration in businesses. So what are the benefits of signing an NDA? Protection of confidential information. An NDA ensures a high level of confidentiality and helps prevent the leakage of important information, especially when sharing sensitive data or business strategies. Legal protection. Signing an NDA establishes legally binding terms that govern the handling and disclosure of confidential information. In case of breach, you can seek legal recourse and compensation, preserving competitive advantage. An NDA allows you to share information with potential partners, investors, or employees without risking the loss of a competitive edge. You can provide access to critical data, knowing it will be securely protected. Cooperation and partnership. An NDA can facilitate collaboration and partnership between counterparties. This enables the development of joint projects and resource sharing while maintaining confidentiality. Attracting investments. Investors often require an NDA before providing funding, which gives them added confidence in the security of their investments. Building trust. Signing an NDA demonstrates your commitment to confidentiality and data protection, enhancing trust with partners, clients, and investors. Compliance with regulations. Sometimes an NDA can help comply with data protection regulations, such as Europe's General Data Protection Regulation, GDPR. You've heard about that. Psychological deterrence. An NDA creates a psychological barrier for individuals considering breaching confidentiality, deterring potential violators. A real-life example. Marvel Studios extensively uses NDA for its projects. Before filming begins, the cast and the crew signs NDA to prevent leaks about the plot details. An effective NDA is specific, leaving no room for misinterpretation. Here is what it must include. Parties. Specify the names of all parties involved, including the party providing confidential information, the disclosing party, and the party receiving such information, the receiving party. Description of confidential information. An NDA must clearly and comprehensively define what information is deemed confidential. This may include technical data, business plans, customer lists, trade secrets, marketing strategies, etc. This agreement section is critical as the affected party will appeal to its contents in case of data disclosure. It's called leakage of the obligations of the receiving party. Describe the obligations of the receiving party regarding confidential information. This section may include rules and procedures for using, handling, storing, disclosing to third parties, notifying the disclosing party of any breaches or leaks of confidential information, and other important aspects related to data protection. Additionally, we recommend including a provision that prohibits the receiving party from contacting any employees of the disclosing party regarding confidential data or making offers of cooperation for a specific period of time. Exclusions specify cases where disclosure of information is permissible. For instance, data may be disclosed by court orders or if it becomes publicly accessible. Duration specifies the term of the NDA. It can be for a limited period of time, like 5 or 10 years, an indefinite period of time, or until the completion of a specific project or the primary contract to which an NDA is appended. Return of confidential information outlines the procedure for returning or disposing of confidential information. Notices establish relevant communication channels with the counterparty, including notifications of data breaches. We advise exchanging messages via email or postal mail. Please do not use platforms like Telegram or WhatsApp or whatever, as those messages could be altered. Sanctions specify the consequences of violating an NDA, including potential legal effects. Establish the disclosing party's right not to limit remedies to damages and to use all legal means of protection. We particularly recommend clearly defining penalties for disclosing confidential information. NDAs are essential across industries. Let's explore a few examples. Technology, protecting algorithms during product demos or joint ventures. Healthcare, securing patients' data during research collaborations. Entertainment, preventing script leaks in the film industry. In 2014, HP sued its former vice president Adrian Jones for allegedly disclosing confidential information after joining Oracle. Jones claimed the disclosed information was already public knowledge. This case highlights the importance of defining exclusions clearly in NDA. Even well-intentioned NDA can fail if poorly drafted. Avoid these mistakes. Overly broad language. Courts may dismiss vague or overly restrictive NDAs. Ignoring third parties. Always account for subcontractors or affiliates. Failure to customize. Generic templates often miss nuances vital to your business. My tip: always consult a legal expert to tailor your NDA to specific needs, or ask a lawyer to make a draft of an NDA you may use in your business. In a 2015 merger between Dell and EMC, NDAs covered the sensitive financial and operational details shared during negotiations. The NDA stipulated confidentiality for 3 years following the merger. What should you do if a breach occurs? Act swiftly and strategically. First, immediate notification. Alert violator of the breach with a cease and desist letter. 2. Evidence collection. Document the breach with timestamps, emails, and witness accounts. 3. Legal action. File for damages or seek an injunctions to prevent further disclosures. Real-world example. In 2018, Tesla sued former employee Martin Tripp for violating an NDA by leaking confidential information about production delays to the media. Tesla sought $167 million in damages, demonstrating the severity of sanctions for NDA breaches. An NDA is more than a formality. It's a shield for your business' most valuable assets. Whether you're a startup or multinational corporation, confidentiality is the cornerstone of trust and growth. Our team at COREDO specializes in drafting and tailoring NDAs to suit your unique needs. Contact us today and let's ensure your business is secure and successful. Please like, leave comments. See you later.